Hi everyone, good morning. Hello. I loved your introduction. Thank you very much for that. I won't be able to do something similar. I'm not that talented. And I loved seeing the photographs outside, the selfies. So looking forward to seeing that on social media. I'm also looking forward to hearing more from the self-advocates and experts in the room from Hong Kong, China, Taiwan, Malaysia, and Singapore. Hope I haven't missed out any countries or jurisdictions over the afternoon of today and over the next 2 days. So I'm really looking forward to learning more about what the situation is here, what your aspirations and goals are, what you want to change, and what the challenges are. And so it's a great privilege for me to share some ideas with you. And I've been asked to talk about litigation, so using the law to achieve whatever it is that you want to achieve, so that your lives are better and other people's lives are better too. And I just want to say at the outset that what I'm going to say is by no means a list of things that you must do or you mustn't do. I'm just going to outline a set of ideas which you can adopt, you can adapt, you can reject, you can forget about, do what you want with them. So I'm not going to present science or truths, just some ideas, some tools that you could use. Or maybe those tools wouldn't work for various different reasons where you're from. And so I think we've talked a lot, or some of these things have been mentioned, which is that's a picture of a toolbox, right, containing, you can see a hammer, and there's probably other tools in there, spanners and other things like that. And so, depending on the task, we need to select a tool, but I'm not very good at DIY, we call it, do it yourself. I'm really bad about that, so I wouldn't know what tool to select. So I might choose a tool and use something and it turns out to be the wrong tool, and I'll use something else. And social change is a bit like that, isn't it? That we have to, maybe we think that, there's a nail, so let's reach for the hammer. But maybe you need to use a different tool. Maybe you need to use one thing after the other. Maybe you need to use more than one tool. So when we come to trying to change societies, there's all sorts of non-violent activities that we can carry out. So I'll be focusing on strategic litigation as one tool, right? But I wanted to say that there are other methods that you can use. And you may have to use some of these methods before selecting others. So pilot projects, I think Michael's going to be perhaps talking about that in a moment, to demonstrate small-scale change that can be scaled up. You might, depending on whether it's allowed in your countries, take to the streets and protest about a certain thing. You may try and work with journalists to get your issues into the media, to get them to report on success stories, and also to get the media to report on things that are not so great, about things in society which maybe you want to change. Political advocacy means asking your politicians, asking the government and the representatives to make changes, to use their powers that we as ordinary citizens don't have, to use their powers to change the law, to change the policy, to reallocate budgets, for example. But also, as we've heard, from Tina, there is an international convention on the rights of persons with disabilities, and there are also other conventions on the rights of children, on the rights of women, on economic and social cultural rights, on civil and political rights. And each of those conventions has mechanisms, has a committee that you can turn to. And each of those committees occasionally reports on how well your country is doing to implement that convention. So you, as members of the public, as NGOs, can influence those systems, as I know that you have been doing. Chosen power representatives, I know, have been to Geneva on a number of different occasions to influence the Disability Committee and the, I think, the Committee Against Torture as well, which is fantastic. You might think that, well, before doing that, or before asking your politicians to change the law, Sharon has told you that they needed some research, they needed some data before making an argument. So NGOs can work with universities. Here we are in one of the prestigious universities in Hong Kong to produce research to make your claims even stronger. So you, NGOs, have personal stories. You can tell the stories of you and your families and the people that you know and love. But we need research to tell us about the numbers of people affected, and also to put the personal testimonies into different formats. And it might be that before you choose to do political advocacy or go to the courts, that you need to increase the legal literacy of your members, of, for example, parents of people with learning disabilities or intellectual disabilities, or increase the legal literacy of lawyers. Because I know that in many countries, and I don't know about Hong Kong yet, but the general lawyers don't know very much about the law relating to people with mental health issues or psychosocial disabilities or intellectual or cognitive disabilities. And it may be that you need to reach out and work with other groups. So what are the women's rights organizations in your countries doing for girls and women with disabilities? What are the children's rights organizations doing for children with disabilities, etc., etc.? And if you can find those intersections where your interests align or coincide with their interests, you're a stronger group. You're certainly a bigger group. So there are all sorts of tools that you can use, and I'm not suggesting that you do the top one, then the next one, then the next one. I'm not suggesting that at all. You're going to have to figure out what's going to work. And a lot of this is trial and error, isn't it? You might try something and it doesn't work, and try doing something slightly differently and it does work. And you will have different experiences of this stuff. So I'm looking forward to learning about what's been tried and what's been successful, what hasn't been so successful over the next couple of days. So I'm going to talk about strategic litigation, which is one of these tools. You may have heard different terms in English. Sometimes we say impact litigation or test case litigation. And in some countries like India, they have a concept of public interest litigation. So I don't know whether you have those terms in Cantonese or Mandarin. So the benefits of using this tool could be the following. I think as a very important first step is that, before talking about the benefits, I should define what I mean by strategic litigation, right? Apologies. what I mean by strategic litigation is it's a method which is used in conjunction with other tools of taking carefully selected cases to court to bring about a significant change in law or policy or the implementation of a law or policy, as well as seeking justice for an individual or the individuals in that case. Right? So it's going to court, seeking a remedy for the claimant or plaintiff, but also with the intended effect of having some wider societal change, bring about change in the law policy. So then the benefits, moving on to this, I think are firstly that a profound effect sometimes of strategic litigation is that a court has documented, the court has found as a matter of fact that something has happened. So a court has found that a person has been restrained. A court has found that a person with an intellectual disability has been denied their decision-making rights. And just the fact that a court documents that has happened has a certain weight in terms of its a historical document of where we are right now. And it has a weight which is greater than an academic writing a journal article or an NGO producing a report. Because this is a court, which is supposed to be an independent body, has found something has happened. But beyond that, litigation can help enforce laws where maybe a local government or mental health or social care providers are ignoring what the law says. Strategic litigation can ensure that the law is interpreted in a progressive way which benefits people's rights rather than takes them away. It can have quite an amazing empowerment effect on so-called victims. And I put quotation marks around the word victim because in law, in human rights law, we talk about victim. You have to be a victim status, for example, to apply to certain courts. But just lawyers especially have to be very careful about this whole concept of victimization because labeling someone as a victim implies that they are a passive, sort of useless recipient of bad things that have been done, and it's a very disempowering label sometimes. But being involved in litigation can be the opposite of disempowering, empowering. It can, you as a victim who've experienced horrible things in your life can put the state or the local government in the dock. So you're in court and you are the plaintiff and the government, or it could be a private entity, it could be an airline company, they're on the other side. And you've got your lawyers representing you. And if you win, you may have been part of a process of creating change that can help other people. So litigation can reverse historic injustices. It can garner media attention to an issue. Even taking a case, not just winning it several years later, but taking a case can interest the media, which can be good. Media can be tricky though, right? Because media, you're not in control of what the media reports. So they can report some nonsense if they want. That's why developing relationships with trusted journalists is quite a good idea. And for NGOs, doing litigation can potentially create funding opportunities, opportunities to access philanthropic gifts maybe, depending on how the funding situation works in your countries. And of course, it can be a catalyst for law reform. So if a court has said that there's been some kind of social justice or human rights abuse, depending on your country, the government may be forced to introduce new laws in Parliament. Also, depending on the court's powers, the court may be able to strike down a law. So it can have that intended effect. But like everything in life, like every one of those tools, there are benefits, but there are also potential disadvantages or risks of using strategic litigation versus one of those other tools. And I want to be really frank with you about some of these risks. I'm not suggesting that these risks cannot be overcome, but in many cases they're certainly there. So one of the risks is that litigation is a very technical tool. You need lawyers, right? And once you bring lawyers on board, depending on who they are, and I know there are a lot in the room, so I don't want to be too rude. But I'm a lawyer, so I can be rude to other lawyers. Once you bring lawyers on board, somehow it gets sometimes really too technical, and what was an issue of social justice and passion gets sort of goes way too technical and becomes sort of clinical in a way. So that might be a risk of introducing a whole new lexicon, a vocabulary, the legal way of seeing the world is just alien to the way that ordinary people see the world and talk about their experiences. So that's a risk. Again, there are ways of dealing with that. Another risk is that litigation is often or always drawn out. So it can go over a very long period of time, years, and people get frustrated, demotivated, drop out, die even. And it creates a lot of stress. I don't know if you've ever been inside a court, even as a witness to something else. Anything involving the legal process is quite stressful. And there is an enormous amount of stress on the person or group of people who are bringing the case, their supporters, their family, the people who love and care for them. But also that stress can shift onto the whole team, the lawyers, which is something which lawyers don't talk about, their own mental well-being. Now in the UK, there is more increase on I don't want to say trauma for lawyers, because there's nothing compared with the trauma that people who've experienced human rights have gone through, but helping and dealing with people and having that responsibility of representing people is something that should be more discussed out in the open. Often strategic litigation will be reliant on the goodwill of people. So you may have to ask for support from lawyers and others on a pro bono basis, ask for their support to do things for free, which is great. You may have to draw in other resources, pull on all of your contacts to make things happen. So goodwill is also a risk, right? Because it may not be as reliable as paying someone to do things. But often in disability rights litigation, the applicants, the claimants, don't have any money or any sufficient money to be able to pay lawyers to take cases on their behalf. So in terms of at the end of the case, when you get a judgment, there are some risks involved there too. So we want to take cases which are going to advance the law, but there's a risk that the judge simply won't do that. They could set what we call a negative landmark. They could say, for example, well, a person with an intellectual disability needs someone else to make decisions in their lives. And you've been arguing in the case that you don't want to give away your right to make decisions. You want to have support to make that decision. But if a court solidifies the law, if they find that the law is adequate, then that could set things back potentially. You also might, and there's lots of judicial comments, you also might get judges using the wrong language. You might get judges enforcing stereotypes about people with psychosocial disabilities or intellectual disabilities, and that's quite unhelpful. You might get a judgment which is a great legal victory, but somehow it doesn't translate into actual change in people's lives. An empty victory, a Pyrrhic victory. And also you might create collateral damage. So there's a case, for example, at the European Court of Human Rights from a few years ago called DH against the Czech Republic, which was about the racial and ethnic discrimination in education. So Roma children, who are an ethnic minority in Central and Eastern Europe, were being labelled as having learning disabilities, and they were sent to special or segregated schools, which were much worse than mainstream schools. And the case was about, hey, European Court, isn't it awful that there's racial discrimination in placing children into special schools? And obviously any form of racial discrimination is terrible. But the court found that there was racial discrimination, but they did so in a way which said that only children who've been properly diagnosed as having learning disabilities, intellectual disabilities, should be placed in segregated education. So from a race and ethnicity point of view, it was a good case, but from a disability rights point of view, well, the court just accepted and acknowledged that special education or segregated education was okay. And from a disability rights point of view, it's not okay. So you've got to be careful about, in advancing our rights, our group of people, are we advancing holistically universal human rights? So, some of the steps of litigation, again, this is, you can pick and choose, you can disagree, but here are 10 steps to do strategic litigation, or at least an idea. And you will notice number 8 straight away, which is conduct the litigation, do the case. And that is what many lawyers, many NGOs jump to straight away. Gosh, there's a horrible situation. Let's take a case. Number 8. What I'm suggesting is that there are 7 things that you should figure out beforehand. Those things can be done urgently. I'm not suggesting delaying for the sake of simply going through the process. But the thing which distinguishes strategic litigation from other types of litigation is that it's supposed to be carefully selected and thought through in order to achieve an aim. So selecting an objective is the first very important thing. An objective, for example, you could say, we want to abolish guardianship, or the total removal of our decision-making powers. We want to abolish that. Or another objective could be, we want to abolish restraints, or we want to bring down restraints to 10%, not 30%, or whatever your objective is. And that objective has to be set, doesn't it, by the people who are most involved. And then they sort of instruct the lawyers to figure out a strategy to achieve that. Then you need to build a team of creative, talented people. Don't accept just one lawyer, because one lawyer can never know all of the... one lawyer never has all of the skills that you need, in my view and experience. So you might need a public lawyer, you might need a lawyer who knows more about disability, you might need other types of expertise. You might need expert evidence from social worker, from psychiatrists even. from nursing experts, whatever your case is about. You need to figure out how you're going to select the plaintiffs, the claimants. And this is where there's a sort of ethical point here, which is that strategic litigation is not like running a law clinic where you just give help to everyone who comes through the door. By selecting plaintiffs, you're inevitably probably going to have to turn away people, to say no to some people. So you've got to select what are the best circumstances that you can imagine your plaintiffs, your claimants to be, in order to convince the judge to make a judgment which achieves your objective. So, and it's going to differ, isn't it, in each case. Once you've got your criteria about client selection, how are you going to find those people? I mean, you might have people in your NGO who've experienced these circumstances that you want to challenge, or you might have to figure out to partner with a university or other NGOs, or you might have to stand outside a psychiatric hospital and wait for people to come out and approach them on the street. You have to be creative. You have to talk about or manage risks. There can be technical risks, there can be financial risks, there could be adverse cost implications in some legal proceedings. How are you going to monitor the risks, keep a risk register, update that, assess how you're doing? Client support. So once you've chosen your clients, what support needs do they have? They can tell you. How are you going to support them through this, very long process probably? How are you going to collect the evidence? So by evidence, I mean it could be disclosure from the local government. You could request social care records, medical records, depending on what the case is about. It could be policy type of evidence. Then you need to create evidence, write witness statements about what happened, what were the effects on the people. And then conduct the litigation, and that's going to be a technical process. Each case is going to be different, depends on the court, depends on the proceeding. And then once the case is over, so number 9, implementation of the court's judgment. So unfortunately, you can, crack open a bottle of champagne when you win the case, but I don't think the work stops there, because you'll probably have to contact media, you'll have to disseminate the judgment, you'll have to work with NGOs to ensure that the judgment, that the laws are changed, the policies are adapted so that the judgment is implemented. And if it's not, maybe you have to take further follow-up litigation. And then finally, take a step back through the process to do monitoring. How are we doing? Are we meeting our objectives? Are we supporting the clients adequately? And then after the process has ended, evaluate how you've done. Be a self-reflective practitioner. And for some lawyers, self-reflection is easier than for others. So I want to just tell a quick story about one person who was involved in strategic litigation. And this person on the screen is Rusi Stanev. And you may have heard of his story. So for many years, he was living with a psychosocial disability, coping all right on his own in a village in Bulgaria, which is a country in Central and Eastern Europe. And when he was in his mid-40s, in 2002, on the 10th of December, and I say that because that's ironic, because that's World Human Rights Day. So on 10th of December 2002, an ambulance came to his house and said, right, get in. And he said, why do I need to go with you? Anyway, he did, and he was driven for 400 kilometers down this road, and he was placed in this house, which was called the Pastra, that's the name of this village, the Pastra Institution for Men with Mental Disorders. And he was placed there, and he had to spend the next several years living there in conditions which were horrible. and he didn't know why he was there. And the way that he had been taken there, the reason that the ambulance had the legal authority to take him there is because he was treated like a parcel. So a year before this, there was a court proceeding whereby his legal capacity was removed. And he didn't know about this. No one told him that this was going to happen, so he couldn't participate in these court proceedings. So his legal capacity was removed, handed over to someone else, his guardian, who arranged, just like you would if you wanted to send a parcel somewhere else. So the legal guardian arranged for him to be sent to this institution in a sort of private law transaction where he spent the next few years. And luckily for him, a Bulgarian NGO called the Bulgarian Helsinki Committee was doing monitoring. They went into these sorts of institutions and monitored people's human rights. And they spoke to him and he said, "This is my story, you need to help me, get out." And they did. And they worked with the organization I previously worked with. And we took a case to the Bulgarian courts, and the judge said, "Hey, Mr. Stanov, you can't bring a case to me, the judge, because you're a person who lacks capacity. You're not a person. You lack the legal standing to bring a case." So the judges in Bulgaria couldn't or didn't help him at all. So we applied to the European Court of Human Rights in 2006. There were 2 hearings, and then 6 years later, such a long time, in 2012, there was a judgment saying that his human rights had been violated, and it was a very long judgment. I won't go into it, but it said, "This is outrageous. Your human rights have been violated. You shouldn't have been treated like this." And back in Bulgaria, that judgment sparked an opening up of sort of a public discussion about the adequacy of the law. So a bit like the conference today, that judgment sparked this process of law reform, which enabled other NGOs to become involved and take the lead. It opened the door to policymakers as well, which had been closed until then. Unfortunately, the law is still the same in Bulgaria because there's been various different political ups and downs. But it had some effect. Right. So, that's just a picture of the horrible conditions inside the institution. So, penultimately, what strategic litigation needs to achieve is a bit of thinking outside the box. And strategic litigation is terribly difficult for some lawyers because it's totally outside the comfort zone of regular lawyers. So what lawyers need to do is the opposite of the things that they do on an everyday basis. So lawyers absolutely need to understand the context within which they are trying to provide the help. They need to convene discussions, or they can use their authority and power as a lawyer to convene discussions with NGOs, with policymakers, to engage with communities. So normally lawyers just have a client, come to their office, they listen to what the client wants, and they go off to court, right? It's kind of transactional. Then they send the bill afterwards. But they need to really engage with the communities, with the groups of people that they're helping, and ask why. Why do you want this thing? Why does the law exist? What's the law trying to achieve? Why are these other groups opposed to what you want to achieve? What are their motivations? They need to do what lawyers find terribly difficult, which is to listen. They need to build partnerships, and also I would suggest bring other resources in. Lawyers are privileged people. They have connections with people who work in media firms, in PR agencies, and so on. And, they should use those connections, or can use those connections, to help develop the case. So I want to leave you with a picture of Rusy Stanev, which I took, and that's the European Court of Human Rights behind him. So he went to Strasbourg in France, which is where the European Court is, and he put his government in the dock, as it were, and won a case there. And on the journey, on the plane from Bulgaria to Strasbourg, this is the first time he left the country, and he didn't have a passport because he was under guardianship, so that was another very tricky thing we had to sort out. But on the plane, he was enjoying his first plane ride, and he said to his lawyer in Bulgarian what I think his case and what many people would struggle to put into words. He said, "I'm not an object. I'm a person. I need my freedom." So for me, that's what it's all about. So what hopefully I've been able to share is not the substantive law that Tina was talking about, not an example of a specific campaign that Sharon's talking about, and not best practices of how to achieve change, which is what Michael's going to be talking about, but a method, the pros and cons of a method which sometimes can be the catalyst for wider reform. So I look forward to learning more from you about how some of these ideas might be able to work in your jurisdictions. Thank you very much.